boleh tekan record. Okay, thank you. Okay. So yang tak dapat tu atau I'm too fast ke, I'm too slow ke, you can play it back lah. As many as you wish. Play it back. Okay, sampai you faham. 100 kali pun tak apa. Oh, it's there on record. Okay, question. What is self-incrimination? I think everybody know about this. Self-incrimination is you are incriminating yourself. You are opening yourself to problem. You're opening yourself to problem. You purposely allow yourself to be subjected to difficulties. Okay, I try to find word beside problem. Difficulties. Okay. Itu basically everybody know lah what is self-incrimination. You are incriminating yourself. You are not incriminating others, but you are incriminating yourself. So sometimes when a witness come to the court, so how you relate this idea of self-incrimination dengan evidence? Evidence, we need, this is relate to apa macam documents or witnesses. You try to produce the document or try to produce a witness. Okay, so sometimes without realizing that this witness, whatever being revealed in court, not only incriminate the parties you intend to incriminate, but without realizing also it can incriminate yourself without realizing. Most of the time without realizing lah. If you realize, then you still disclose it, then it's hard to say lah. Okay, I think you can't do anything. Okay, so the issue now, does the law allow some kind of protection? Okay, privilege. Okay, from being incriminate yourself. Of course, being a human being, a lawyer, I think is okay lah, because we have been trained, you and me, same. We have been trained how to speak. We have been trained to know what we can do, what we cannot do. But for layman, it's a different story. They don't know. Of course lah, it's logic. Okay, layman, okay, they don't know. Okay, whatever they think everything is okay to be revealed. Okay, sebab banyak baca surat khabar ke, banyak baca apa online ke, kata kita hendaklah apa kebebasan bersuara okay, di bawah Perlembagaan Persekutuan kan, everybody know artikel berapa perkara berapa kebebasan bersuara, Syami ingat tak?
Sekejap, saya lupa tak?
Ingat tak artikel berapa Federal Constitution tu?
Perkara 5.
5? 5 ke?
10.
5 is liberty. 10 right? Kebebasan bersuara, kebebasan untuk berpersatuan. Itu dia. Okay, tapi ada bawah tu ada limitation. Okay, perkara 10 clause 2. Okay, bukan subsection. Clause. Okay, clause 2. Okay, it said that every freedom ought to be limited lah. Okay, so layman mana tahu yang limit-limit ni, yang selalu tahu kita je. Okay. So diorang ingat kebebasan suara, they can say anything including in court. So without realizing that, whatever they say, okay, can later be used against them in court of law. Okay, so that's why we need to create this kind of privilege lah. Okay, the idea of creating this kind of privilege is to encourage people. Number one, to encourage people to talk, and number two, okay, of course, to support us to build up our case lah. Kalau semuanya cannot be disclosed, then we lose our case lah. We need evidence, right? So kalau semuanya kena protected, so baik tak datang mahkamah pun okay, silent je, bisu. So there's no point. Okay, so this is the idea of self-incrimination. Self-incrimination is the act of accusing oneself of, as I said lah. So I don't think there's need to repeat about this lah. You're incriminating yourself. You're saying that, okay, you are doing some sort of a crime whatsoever. So we have this magazine. Basically, there's a lot of magazine. I just want to share one lah. Okay, I think you all pernah tengok cerita tu kan, kartun tu kan, apa tu, yang ikan tu? Finding Nemo. Ni Nemo. Nemo debate Prodier say absent. Okay, so Finding Nemo means finding no one. No one can be required to be his own betrayer. Okay, no one can be required to be his own betrayer. So Nemo, none. Okay, no one can be required. Okay, so that's about it. So far semua faham ke?
Faham.
Kalau tak faham,
Faham.
just unmute je tau, cakap je.
Baik, doktor.
Boleh Abdul Had
Boleh, doktor, boleh.
Okay, that's good. Slide kita tak banyak ni, 39 je. Sekejap ni. So the privilege against self-incrimination forbid the government, not only the government lah, the court. The government means the authority lah, the police whatsoever, and the court from compelling anybody, okay, to give testimonial evidence lah, which likely to incriminate him or her during a normally in criminal case lah, okay. The privilege against self-incrimination enables the defendants to refuse to testify in certain kind of criminal case lah, okay. This right or privilege, okay. The right privilege him not to answer. Him means the accused or the witness not to answer official question put to him or her in any proceeding. Okay, not only criminal, it can be civil also tau. Okay, it's not only limited to criminal, civil as well. But normally I say it's criminal because banyak sangat case criminal. Because criminal is, as I said, the application tu is very serious lah compared to civil. Case jenayah tu kan. Okay. So the implication tu besar sikit compare dengan civil. Tapi basically you can use this privilege both area lah, civil and criminal. Formal or informal, where the answer might incriminate, okay, for criminal proceeding in future criminal proceeding. So kalau you jawab, so dia boleh rely on this protection lah from answering question. I don't want to answer this question because if I answer, it will open me, okay, mendedahkan diri saya kepada apa? Pendakwaan, okay, dalam kes-kes jenayah pada masa akan datang. Kang, saya nak balik rumah, belum keluar bilik kamar hakim, bilik mahkamah ni kan kena tahan polis kat depan tu kan. Okay. Polis sedang menunggu saya. Okay. Itulah dia. Itu maksud dia. The legal protection or privilege against self-incrimination is directly related to the question of torture of extracting information. Why we have this kind of protection? Because what we have learned last semester lah, you relate to what we have learned last semester. Kan kita cakap last semester tu about confession, admission, right? Okay, confession and admission something which is must be given voluntary lah. Okay, if you've given involuntary, then it will be unfair lah. Okay, unfair. Of course, some of you might ask the question, illegally obtained evidence, the court is not bothered how the evidence is obtained as long as relevant, right? Section 5, but you must remember, as I said last semester also, this general principle is subject to exception. Kita ada tu, ingat tak yang apa tu? Krishna Rao Gurumurthy tu, PP against Krishna Rao Murthy. In accepting such illegally obtained evidence, the court must also weigh between apa probative value and prejudicial effect. If the prejudicial effect is okay higher than probative value, so you still cannot submitted such evidence. Is too harsh, is unfair for the accused or the winner whatsoever. In violation of this right are inadmissible against them during a criminal prosecution. In absence of such protection, when a witness is nevertheless compelled to answer, his or her answer are inadmissible against him or her in later criminal privilege or criminal prosecution by virtue of this privilege. So we cannot, in general, this kind of privilege is not only applicable in our country, it's all over the world, standardized. So what I'm telling you at the beginning, before I go to Malaysia dia lain sikit. Ini kan Malaysia tau. Ini general. Okay, Malaysia dia kita dah advance, nanti I tunjuk you. This is generally all over the world, okay, Commonwealth country ke non-Commonwealth country. The idea of the protection is to protect entirely 100% the witness from being subjected to any prosecution lah. Okay, not only to protect the witness or the suspect from future prosecution, but also okay to allow them to remain silent in court. Okay, to allow them to remain silent. Maknanya diorang boleh refuse to answer question entirely. Okay, in the court of proceeding. But in Malaysia different. Nanti I tunjuk. Kalau you ingat lagi kan yang sebelum PKP tu kita sempat juga buat ni talk ni. Siapa tu ingat tak? Siapa nama ni? Judicial Commissioner yang Arif. Siapa nama ingat tak?
Beth.
Mary Peter.
Correct, Fisa. Okay. Correct, Imran. This yang Arif Married Peter okay, Judicial Commissioner Pesuruh Jahaya Kehakiman di Mahkamah Tinggi Sivil Johor Bahru. Okay, so jadi siapa Anybody know?
Tak tahu rasa.
Tak kenal
Wafi.
Ini yang Arif mana ni? Yang Arif. Mahkamah Syariah ni. Apa yang baru tu dekat Perak tu? Mahkamah Utama Syariah Yang baru wujud tu. Satu level lagi. Kita ada Mahkamah Syariah, tempat Perak dia dah buat lagi satu Mahkamah Utama Syariah. Paling tinggi sekali. Perak.
Betul.
Okay, yang Arif Ni siapa ni? This lady.
What's your ID?
Ha? Yang Arif tu future yang Arif. Okay. Yang Arif. Okay. Mahkamah Tinggi Civil. Okay. Seberang Pride. Seberang Pride. sorry. Okay, kalau you ingat lagi, tajuk dia pasal polygraph kan? Okay, it's relate also privilege against self-incrimination tau. Polygraph tu macam, in some country, okay, they are forcing you to take the polygraph test. They are forcing, compelled. So, this also can be subjected to privilege against self-incrimination tau. So, means that whatever the result which come out from this privilege against self-incrimination, okay, cannot be disclosed in court lah. Okay, because you are compelling a person to undergo this test, polygraph test. If I'm not mistaken, which country there's allowed privilege against self-incrimination? Not all country lah. Some country said you cannot rely on privilege against self-incrimination for this polygraph test admissibility. But some country, yes, India. Kalau you refer India dia dah ada court case, Supreme Court, highest court in India. It's mentioned clearly you cannot use this result of this polygraph test as an evidence in court. Okay, because it's against privilege against self-incrimination, because you are compelling a person to compel a person to answer a question based on that polygraph test. So it's not permitted. Okay. In India lah. In Malaysia, no issue yet. Okay, because polygraph test also we are still there's no case law which allow it to be submitted yet. Okay, I think you dah datang, you tahulah, you dengar itu Kalau nak hantar pun polygraph as an evidence is under the virtue of section 45 right? Mary Peter said itu kan, expert witness. Okay, so far tak ada siapa pakai okay, but internal investigation adalah untuk jabatan agensi tertentu je, tapi so far sebagai bahan bukti mahkamah I never tak jumpa lagi court case okay. A witness can refuse to answer a question or give documentary evidence, not only testimony tau, document pun. Okay, only when the answer or document would incriminate the witness For criminal defendant, the privilege against self-incrimination includes the right to refuse to trial at trial. The main purpose of privilege against self-incrimination are to prohibit the compelling of self-incrimination testimony from the party or witness. Okay, we cannot compel them. To guarantee the right of remain silent. Okay, absence immunity. So kalau tak ada immunity tu macam case false confession, false admission tadi tu. So we have this privilege, so there's a guarantee right being given to them lah. Ni apa bawah ni? To prevent the use of legal compulsion. Okay. Legal compulsion macam case macam illegally obtained evidence macam case Krishna Rao Gurumurti tu dalam case confession tu kan, police they use certain authority, not only police lah, they use didn't follow the correct procedure. So that's the reason why we have this kind of privilege to protect this witness from being subjected to future criminal prosecution. However, the privilege does not allow a witness to refuse answer a question because ini penting Kalau you cakap tadi kalau you ingat apa yang cakap tadi, kita tak boleh guna whatever answer being given by the witness cannot be subjected to criminal prosecution kan? Okay. However, the privilege does not allow a witness to refuse to answer a question because the response can expose the witness to civil liability. Tadi criminal je. Maknanya civil liability tu dia kena jawab soalan juga lah. Civil liability or social disgrace, okay? Or loss of status or reputation. Or even loss of private employment. So kalau dia jawab tu boleh menyebabkan dia hilang pekerjaan, maknanya dia tak boleh pakai this kind of privilege lah. Okay. This macam limitation semua faham kan apa nak tanya soalan ke? Ada bagian ni. Ini limitation dia. Civil liability, social disgrace, loss of status, even a loss of private employment. A witness cannot claim the privilege on the ground that the answer or document can incriminate a third party even. Okay, incriminate a third party. Okay, this one is self-incrimination, not a third party. Okay, so kalau you jawab soalan tu kalau saya jawab soalan tu, okay, tak incriminate saya, incriminate Syami, boleh lah. Okay, sorry Syami. Okay. So moreover, the right of self-incrimination does not apply when individual testify before apa benda ni? Self apa dia? Nampak tak? I tak nampak lah sebab dia ada box Self apa?
Self-regulatory.
Self-regulatory organization. When the individual testify before a self-regulatory organization. So this is mostly applicable in macam court case situation lah. Rather than informal punya organization. The privilege is bar against compelling communication or testimony. However, that compulsion will make a suspect or accused as a source of real or physical evidence does not violate it. Okay, so this privilege only protect communication. Macam marital communication privilege is protect communication. So dia tak protect benda-benda lain macam physical evidence or so real evidence whatsoever. A suspect voluntarily, knowingly and intelligently can waive his or her right under privilege against self-image. Maknanya kalau dia purposely nak testify, then he or she is permitted to do so. Okay, so dia ruling, maknanya dia boleh waive dia punya right lah kalau dia voluntarily, secara sukarela. So we go one by one before we go to Malaysia. We refer to several country first, tak banyak country pun. US, UK, then Malaysia lah. Dekat US very good, very clear, not good lah, clear. Why clear? Because this kind of privilege is mentioned under dia punya Perlembagaan Persekutuan. Okay, perlembagaan dia. Okay, under 5th Amendment. So kalau you tengok American movie, banyak American movie. Okay, sometimes the witness come to the court, they say that I would like to plead this 5th Amendment. 5th Amendment mean privilege against self-incrimination means that the witness or suspect has a right not to disclose any information. Is protected under their 5th Amendment, dia punya Article 5. Okay. To plead 5th Amendment is the refusal to answer a question because response would form a self-incrimination evidence. Okay, so once they plead 5th Amendment, so the court or anybody in court cannot force them to testify lah. That's it, finish. He can go back. Okay, I would like to plead 5th Amendment. Okay, sometimes you watch movie, there's a script mentioned about this plead amendment. American movie macam Law and Order. Okay, banyak dia. So dia dah mention bahawa dia punya state constitutional, is constitutional right. So tak boleh force. Okay, kalau force juga maknanya judge tu dia dah go against the constitution. Judge are erred in law in US. Okay, so walaupun benda tu ada dalam constitution diorang, tapi case Miranda against state of Arizona. Okay, 384, 1966, ni Supreme Court level punya case. This guy, this photo, you recall is Miranda lah. This happened to be illegal immigrant from Mexico. He went to the cross border to Arizona. Kalau you tengok American punya map to Arizona is border with Mexico, right? Okay. So he went to America, okay, illegally, being caught by the police lah. Okay, so the police arrest him. Okay, when the police arrest him, the police interrogate him. Okay, ask him so many questions. And Miranda, being a layman, also do not know what he can do, what he cannot do. He give all the answer. So because of that answer, he being being sent to imprisonment lah in US. He's not happy. The lawyer not happy. Make an appeal lah because he being forced to answer question without the presence of lawyer, without following a proper procedure. Okay, so the Supreme Court, the highest court in US said, okay, is correct lah, whatever the defense counsel. So they overruled the decision of lower court, okay, state of Arizona, said that the police is wrong to use all the information given by Miranda against him lah. Okay, okay. So the police officer being reminded about the existence of the 5th amendment tu okay, under the federal constitution, everybody have a right, okay, not to self-incriminate themselves. Okay, and because of this case, this is very important case. Because of this case, the police in throughout the United States of America started to use Miranda warning card. Okay, Miranda warning card tu apa maksud dia? Kalau you watch American movie tu, kalau police arrest anybody, suspect, witness, whatsoever, suspect, they said you have the right to remain silent. Anything, okay, you said will be used against you in the court of law. You have the right to employ an attorney. Okay, okay. If you can't afford to employ an attorney, okay, you'll be provided with one. Okay, do you understand what I have said to you? I dah memorize, tak payah baca pun. Okay, so I think you come across right script drama ni. So every police in United States, before they can become a police, okay, ada probation, they must able to memorize this script lah. So that kind of script being developed by virtue of Miranda. Okay, so that script, okay, being developed to respect the Article 5 of the US Constitution lah, the right to prevent a person to self-incriminate himself or herself. Itu dia. Because of this case, they started to develop that Miranda warning card. You have the right to remain silent. Okay, Malaysia tak ada tu Malaysia ada ke? Siapa polis ni? Okay. Anybody sukses here? Faiz, apa ada tak ada?
Aiman Jambang.
Aiman polis lah, sukses. Kena hafal tak? Ada kad tak? Miranda card You have the right to remain silent. Mana Aiman?
Tak pasti ya, Doktor.
Ha?
Tak pasti.
Tak pasti? Okay Aiman, tak apa. Dia tak pasti. So polis tak apalah, nanti ada talk kita jemput polis, kita tanya polis. Apa Miranda card orang? Okay, kat Malaysia ni. Rasa macam ada je. Awak ditahan. Okay, rasa macam ada. Okay, tak apalah. Position in England. So in America, they can rely on this privilege against self-incrimination lah. Absolutely. They have the right to remain silent all the time. The court cannot force them to testify anything because, okay, whatever they write may be used later on to incriminate them for future punya criminal case. Same go in UK lah. Okay, sama je UK dengan US. You refer to case of Triplex Safety Glass Company Limited against Landsgate Safety Glass 1934 Limited 1939 2 Queen Bench page 395 In this case where an action brought against a company and its director by another company claiming damages for libel and slander interrogatories was administered to both defendants directed to obtaining admission of the publication of alleged libel and slander lah. Both the defendant of the company and the director refused to answer on the ground that, to their best of knowledge, information and belief, the answer would tend to incriminate them. So they want, okay, both this party defendant to produce certain things, but they don't want because they know whatever they're being forced to produce will later on be used against them in the future criminal case. Maknanya, okay, ada something not right lah dalam dia punya information tu So the court held that the refusal of the defendant was justified lah. A man could not be compelled to answer a question directed to procuring his confession of a criminal act merely because it was unlikely, okay, that that would be prosecuted to company, okay, was entitled to the same privilege. Not only individual but also applicable to the company. So this kind of privilege not only applicable to individual to the extent of the organization. Okay, if a man, okay, or even an organization cannot be compelled to answer a question lah, okay, for a criminal case because it was likely that there's a possibility that the person or the organization can be subjected to criminal punya prosecution. Okay, so in other words, same like America, they can rely on this privilege against self-incrimination means that they can remain silent at all time. Okay, absolutely. They cannot be forced to answer a question. How about Malaysia? Malaysia is very unique. So Malaysia dia tak ikut macam US dengan UK tadi tau. Malaysia dia unik sebab kita unik sebab kita ada statute. Okay, open your statute section 152 subsection 1. Okay, it's mentioned that a witness not accused from answering on the ground that an answer will incriminate. Okay, tu dah clear dah. So maknanya witness cannot excuse himself or herself from answering a question just because the answer will criminate them. Nampak tak beza tadi dengan Amerika dengan common law? Nampak tak? Ada siapa yang tak nampak lagi? Amerika tadi, they can excuse from answering question, but Malaysia, they cannot excuse themselves. So means that they must answer. Whether or not the answer will incriminate them for future criminal, they must answer. But in US dengan common law, they can refuse to answer. Itu beza Amerika common law dengan Malaysia. Nampak ke? Semua okey? Okey.
Okay.
Clear?
Clear.
Tengok subsection 1. Clear apa? A witness shall not be excused from answering any question as to any matter relevant to the matter in issue, whether in civil case or criminal case, upon the ground that the answer to that question will criminate or may tend to directly or indirectly to criminate him. Itu dia. So makna dia kena jawab juga sama ada dia suka ataupun tidak. He can be compelled to answer. Okay, in court. Itu dia. Saksi tidak dikecualikan daripada menjawab atas alasan bahawa jawapan itu akan melibatkannya dalam jenayah. Okey, seseorang saksi tidak boleh dikecualikan daripada menjawab apa-apa soalan tentang apa-apa perkara yang berkaitan dengan perkara persoalan dalam mana-mana guaman atau dalam mana-mana prosiding sivil atau jenayah atas alasan bahawa jawapan kepada soalan itu akan melibatkannya kepada dalam jenayah atau secara langsung atau tidak langsung cenderung melibatkannya jenayah. So, he has no choice, kena jawab juga. Okey, itu dia. Tetapi dalam subsection 1, 3, 2 tu kita ada subsection 2 dan subsection 3. Jangan baca subsection 1 je. Okey. Kita ada 3 subsection esok. 3. Kena read together. Okey. Subsection 2 jawab apa? No answer which a witness shall be compelled by the court to give shall subject him to arrest or prosecution or be proof against him in criminal proceeding except a prosecution for giving false evidence. Perjury. Okay. Perjury je dia boleh being subjected. Tapi itu. Okay, nampak tak clear? Subsection 1 kata witness have no, they cannot excuse from answering question. They must answer question. But subsection 2, a guarantee being given. Assurance being given. Macam parallel evidence. Assurance, guarantee, warranty. Whatever answer you give in court now in front of me will not be used later on against you in court of law for any criminal proceeding. Okay, is it clear? So you all rasa-rasa yang mana okay? Common law American ke Malaysia okay?
Common law.
Malaysian.
Kenapa
Common
Malaysia
law.
okay?
American.
American punya best.
Apa pula American best? Kenapa American best Imran? Cerita sikit. Senyap dia.
Sebab dia bagi refusal kepada witnesses daripada menjawab soalan-soalan yang boleh incriminate dia, yang mana mungkin masa trial dia kena press, dia kena intimidated. So it is good lah. So he have a wider choice.
Okay, I respect your opinion. Anybody like to give opinion again? Siapa lagi?
Saya sokong Imran.
Thank you. Okay, penyokong. Okay, saya sokong. Okay. Okay, Wafi. Okay. Anybody else?
Sebab doktor,
Yes, Swaili.
dia dah cukup baik dah nak tampil tu. So
Okay.
kalau tak nak bagi, tak nak jawab tu, bagi je lah.
Okay, Swaili. So it's different on your perspective lah. But if you ask me, Muzaffar, my own opinion lah, I think Malaysia is better. Why? Because okay, you are providing evidence. We need evidence to support our case, right? Kalau semuanya being protected macam Amerika dengan common law tadi, macam mana bila case tu nak setai? Susah. Okay. So dalam Malaysia, the beauty is that okay, you must give evidence, but at the same time protection being given to you. Okay, so macam win-win situation tau. Okay, kita dapat evidence, at the same time protection being given to you. Jawablah persoalan ni. Tapi jangan risau. Apa benda yang awak jawab tidak akan mendedahkan diri awak kepada future criminal. Macam Amerika dengan tu, macam common law, memang absolute, tak perlu jawab. So means that dia senyap je lah. So maknanya apa-apa yang dia tahu ke, okay, kita tak dapat evidence daripada dia. So case tu akan menjadi lebih sukar di Amerika dan common law, because this is absolute silent kat Amerika, okay, because they can rely on their absolute privilege against self-condemnation. So kat Malaysia ni dia macam dah lain sikit tau. Dia macam lain sikit. So dia boleh bagi, tapi apa yang dia bagi tu akan diprotectkan. So macam win-win situation, mahkamah dapat info, at the same time the witness being given a protection. Itu saya punya opinion. Okay, ada apa-apa nak jawab?
Tapi sir,
ya.
Sir,
benda yang dia bagi tu nanti orang bukan akan investigate ke, sebab dia takkan guna main evidence tu, tapi macam contohnya dia kata saya ada buat report tentang menunjukkan audit ni salah apa benda. Nanti orang bukan akan cari ke evidence tu, bukannya statement dia, tapi evidence yang report tu yang dia dah cakap tu, untuk
betul.
buat investigation kepada dia.
yes.
Betul.
Yes, dia
Investigate
macam
pun
dia suruh untuk the authorities to have a very scrupulous and thorough investigation. So it will not So the prosecution lah itself has a very strong case.
It's okay, but the issue now, whatever investigation, whatever they came out, the witness still being protected because the guarantee being given under section 2. The privilege is still there. Okay, the only thing is that is assist the court to settle the case immediately. Okay, and at the same time, guarantee, assurance, warranty is given, a protection being given, a privilege is being given towards this witness. Nampak tak? Beza dia. Okay, so investigate lah, no problem. There will come a new things whatsoever. Whatever it is, when it's still protected. Okay, it's mentioned here. No answer which a witness shall be compelled by the court to give shall subject him or any arrest or prosecution or proof against him in any criminal proceeding. Mana kan kalau dia menipu terus, itu memang perjeri lah. So it's still protected.
Tapi
Nampak.
Contohnya macam kalau dia kata yang macam saya cakap lah, dia kata dia ada evidence yang menunjukkan self-incriminatory, ada piece of evidence, contohnya dokumen lah. Nanti bukan ke menyenangkan pihak prosecution untuk tender dokumen tu untuk prosecute dia lah, tapi prosecution tak akan rely kepada statement dia, instead dia akan rely kepada evidence of the document. Maksudnya adakah semasukkan
tak boleh juga kalau dia rely on kalau prosecution tu rely on ada evidence pun untuk go against him, at the end of the day they will relate where they got the source of information. We come from this testimony is protected lah, Wafi. Okay.
Oh, I
so
see.
prosecution pun akan spoil dia punya case beyond reasonable doubt. Gagal beyond reasonable doubt tu.
Oh, faham. So maknanya dia go beyond the statement jugalah maknanya.
Dia akan datang juga. Nanti dia akan tanya juga, mana you dapat information ni? Oh, before ni dia bagi information ni dalam ada satu proceeding tu. Okay. Dah dapat kat situ, tiba-tiba tersangkut bawah subsection 2 ni. So tak boleh juga. Nampak tak, Wafi?
Tapi kalau prosecution cakap dia tak dapat daripada witness tu, contohnya ada orang bagi dia tak boleh nak macam dia dah establish yang tak ada relation kepada statement tu, boleh still submit kan?
So defense tu nanti dia boleh raise this issue pula. Okay, so dah ada issue, ada doubt. So gagal juga prosecution. Di mana ada kemauan, di situ ada jalan. Mana awak dapat information tu? Daripada testimoni saya dulu kan? Dah habis tersangkut. Nampak tak, Wafi?
Oh, faham sir. Okay, thank you sir.
You're most welcome. Jangan risau. Okay, when you are in that situation, people are very good. Okay, the beauty about being law is that people are very good in arguing. Okay, and tracing the information. Where on earth the origin of the information. Subsection 3 Sebelum memaksud subsection 3 cakap apa? Before compelling a witness to answer a question, hakim tu hendaklah explain kepada witness mengenai subsection 2 ni. Okey, mohon saksi jawab soalan. Okey. Tetapi apa yang awak jawab, tak perlu risau, tidak akan digunakan terhadap diri awak untuk apa-apa pendakwaan di masa hadapan. Kena bagi itulah. Gagal bagi tahu ni pun hakim tu salah di sisi undang-undang. Sebab dah mention bawah subsection 3. Dia kena ikut. Okey, dia kena ringat. Dia tak boleh expect witness tu know everything. Itu dia. So hakim, it's a duty of hakim lah. Okey, mahkamah hendaklah menghuraikan kepada saksi maksud subsection 2 ni. Okey, apa maksud dia, kena detail. So hakim dia supposed to know lah. Okay. So differences between English law and Malaysian law is very obvious lah. Okay. Macam kes Chai Ahsan against R 1954, Malayan Law Journal 217. The maxim is enforced in a different way because under our section 132, of course previously evidence ordinance, now evidence act, a witness is bound to answer all questions, even though they may tend to criminate him or her. But if he's forced to answer such question, no proceeding can be taken against him or her based upon any answer being given except for proceeding for perjury. Okay, kalau dia bagi testimoni menipu itu boleh. Okay, itu beza antara common law dengan Malaysian. So macam common law dengan American tadi dia silence. Okay, but Malaysia they have to provide answer, but the answer will be protected. Okay, itu beza dia. What being said by Spencer Wilkinson J ni lah dalam kes how to pronounce it? Chi Ahsan against R. Okay. Question, does the privilege exist in Indonesia? Okay, so some of you might ask a question because since the witness being forced to answer a question, so that is against the idea of privilege in the first place. Okay, Common law tu memang lah. America tadi, the privilege is there because it's absolute. The witness has a right to remain silent entirely. But in Malaysia nampak macam dah hilang je because they're being forced to answer question. So because of this issue, there's a two school of thought Banyak betul school of thought dalam. Betul lah, in law, they're supposed to have a lot of school of thought Okay, macam tu. It's because everybody have their own view. Okay, macam I ada my view, Wafi dia punya view, Imran dia punya view, Syami pun dia punya view Okay, it's healthy lah. Okay. So the first school of thought mengatakan bahawa privilege has already gone. Okay. You refer case Television Broadcast Limited against Mandarin Video Holding 1983, 2 Malayan Law Journal 346, as well the case of AG of Hong Kong against Zawiya Wan Chi 1935, 2 MLJ 620. It's mentioned that the maxim is enforced in a different way in this country. The court regarded as something which is an error lah. Section 1321 has already withdrawn or removed the idea of privilege entirely. It's followed that the privilege can no longer be enforced or invoked. It is not there anymore. This is the first school of thought lah, because according to them, 132 section 1 said that since the party have been forced to testify, so there's no longer the idea of privilege against self-incrimination in Malaysia. But the second school of thought said that the privilege still there lah. Okay, although we have section 132 subsection 1, but we must not forget we also have subsection 2 and 3 just now. Okay, although a witness being forced to testify, a protection being given, okay, towards him or her from being subjected to criminal prosecution in the future. Okay, so the second school of thought say that the privilege is still there. Okay, you cannot say that it's totally gone. It's there. So this is being celebrated in the case of PMK Raja against Worldwide Commodity Siam Berhad 1985, 1 MLJ 86. Okay. So because of these two school of thought, I developed my own opinion lah. I believe PASI still there, privilege against self-incrimination still exists in Malaysia lah. However, I use the word modification. Okay, it's been modified by virtue of section 132 of the Evidence Act. The privilege is still there. A witness still can rely on protection, but at the same time, the witness are bound to answer a question put forward to him or her lah. But with a full understanding that by the witness, whatever being answered by him or her will not be used against him or her later in court of law. Okay, so that will be my humble opinion. Okay, modified. Fuzzy still exists, but being modified. Okay. So Alhamdulillah everybody, after 4 weeks, we finish privileges. Marital communication privileges, lawyer-client privileges. Last week we discussed about privilege state, crown, public interest immunity privileges, and today privilege against self-incrimination. We have been subject to modification. Any question?
Doktor, dekat India sama dengan Malaysia
Dekat India?
India privilege.
In India, they have 132 also, same like our Evidence Act. So yes, subsection 1, 2 and 3. So I believe, yes, it is the same. Tu sekejap sebab dekat sebelah saya punya, sebab saya tengah buat online ni, best kalau online ni. Bagi saya check sekejap sister. Evidence Act India Tahun berapa India semua? Tahun 18 berapa? Nak test.
87.
Berapa?
87.
97?
87.
Indian Evidence Act 1880s. Tunjak saya tengah buka ni. 1872 sister. Tunjak saya check sekejap 1872 Indian Evidence Act. Nah, peringkat Allah, nak buka, nak kena check browse. Okay. Dah buka dah. 132. Where is it? Nak confirm betul-betul. Mai tahu borrow MN semalam ke? Okay. Dah check lah. Okay, in India, section 132 also, witness not excused from answering on the ground of that answer will criminate lah. Okay. But interestingly, kat India sister, dia tak ada subsection 1, 2 and 3 tau. Dia cuma ada ni je, 1, 3, 2. Okay, tapi dia sama macam subsection 1 kita. A witness shall not be excused from answering any question as to any relevant to the matter in issue in any suit, civil or criminal, sama macam Malaysia. Upon that ground that the answer to the question will criminate or may tend directly or indirectly to criminate such witness, or that it will expose or tend directly or indirectly to expose such witness to penalty of forfeiture any kind. Dia cuma ada proviso je sister. Dia tak ada subsection 1, 2, 3 okay. Dia cuma ada proviso je. Provided that no answer will which a witness shall be compelled to given shall subject him to any arrest prosecution or to be proved against him in any criminal proceeding except prosecution for giving false evidence by such answer. Betul lah. So dia punya subsection 2 dia jadi proviso system. Okay, kita ada subsection 2. Dia jadi kita punya subsection 2 tu dekat India dia bawa proviso je. Maknanya samalah. Okay, mana dia kena jawab juga whether he like it or not, but whatever the answer being given will not be open him to future criminal proceeding except in case of perjury. Beza dia dengan India, dia tak ada subsection 3. Subsection 3 tadi kat Malaysia, the judge duty to remind the witness about subsection 2 ni. Tapi kat India tak ada. So Malaysia still the best, Imran. Even compared to India. Is it okay, sister? Swahili tanya dia.
Okay, thank you, Doktor.
Malaysia still the best, Swahili. So kita detail. Section 1, 2 and 3 lagi.
Okay.
So even best than India. Walaupun India ada statute, Malaysia still not bad lah. Okay. Yes. Proud Malaysian. Ada apa-apa soalan lagi?
Doctor.
Yes, Syami.
I have questions on the limitations that we have discussed earlier about the civil liability, social disgrace. That limitation, is it referring to any specific country?
Specific country, that one is applied in US lah, for sure. That one because it's protected under their constitution, okay?
Yeah.
But the limitation is to what extent they can use the privilege. As I said, the answer will not open them for criminal prosecution, right? Not only Malaysia, America and common law also, UK, but people might ask question, how about civil liability? Sebab dalam statute tu dia tulis criminal je kan, kalau you ingat tadi lah, okay Syami ya? So it stands to show that there's a possibility that a person cannot be used this kind of privilege to protect themselves for civil liability, Syami.
Okay.
Civil liability and being mentioned just now. Because it's mentioned that our statute tadi is a criminal saja. Kalau India pun sama juga ya. Tadi as mentioned kat tadi open question will criminate or maintain directly or indirectly criminate such witness. Okay, for any kind issues wording or criminate juga. Criminate means criminal lah. Okay. In criminal proceeding. Dia tak cakap pun civil proceeding. Okay. Itu dia. Dapat Syami?
Yeah, so meaning that Malaysia is only limited to criminal proceedings.
Yes, I think you can put it that way lah. Okay, put it that way. Because saya tak jumpa case. I try to locate for a local case talk about this issue, but so far they are most only focusing on criminal case, Syami.
Alright.
Okay. So far they're focusing on criminal case. Itu dia.
Okay. Right. Thank you, Doctor.
You're most welcome, Syami. Any more question? Semua okey kah? Ada berapa student hari ni 42 orang bukan kita ada 46. Okay. Okay lah, I think semua okay InsyaAllah Entahlah. Okay kot. Boleh No problem. Not a big issue.
Doktor.
Ya? Yeah?
Kalau syariah punya court pun dia sama juga ke dia punya privilege je?
Syariah, to be honest lah, syariah I tak I tak pasti yang syariah tu, tak berani nak jawab. So you kena buka syariah evidence akta keterangan mahkamah syariah tu. Cuba tengok bawah tu ada tak apa perlindungan terhadap saksi untuk cakap tu. Mahkamah syariah I tengah buka sekarang internet ni Mahkamah syariah keterangan. Anda tengok wilayah persekutuan lah. Wilayah persekutuan is good because selalu negeri-negeri ni dia ikut wilayah aje. Sorry to say lah. Okay. Saya tengah buka saya. Akta keterangan Mahkamah Syariah wilayah persekutuan ya. So diorang ni section tak banyak tau. Banyak juga. Okay. Tak banyak, 132 section je. Okey peruntukan khas berhubungan testimoni saksi section 119 sampai 129 Akta Keterangan Syariah ni menentukan saksi adil. Okey, saksi kompeten lah tu kalau kita punya section 118 So kat sini 119 saksi adil tu kompeten lah. Saksi hendaklah diperiksa oleh pihak yang berhubungan dengan dia, pemeriksaan rahsia, bilangan pemeriksaan rahsia, pemeriksaan terbuka. Testimoni dalam pemeriksaan terbuka sebahagian daripada syahadah bila saksi tidak perlu diseksa. Penafian terhadap saksi apabila dapatan pemeriksa saksi berbeza. Saksi tak mati atau hilang bila saksi dinanti. Testimoni ya. Sekejap bagi saya check. Okey, Abdul Had tadi. Okey. Saya rasa kan bawah ni dia tak ada particular sangat pasal privilege against self-examination. Tapi Abdul Had, dalam dia orang lebih terbuka tau sebab everything is based on hukum syarak. It's mentioned under Akta Keterangan Syariah tu. So hukum syarak dia banyak rely on this mazhab-mazhab tau. So ada mazhab mengatakan kalau saksi, testimoni daripada saksi tu boleh mendedahkan dia kepada perkara yang memudaratkan. Itu macam Arab. Memudaratkan. Memudaratkan. So memudaratkan tu I can assume as a self-incrimination lah. Itu yang saya dapat. So means that the court, a qadi, they cannot, a qadi, pronunciation, qadi, cannot force this witness, to give testimony in certain area lah. Kalau perkara-perkara tu yang boleh memudaratkan, saksi dia, Boleh dapat tak Abdul Had?
Boleh.
Boleh ya?
Boleh.
Nak kata per se tu saya tengok sekarang tak ada, saya tak nampak pun self-incrimination, So saya lebih kata dia macam open argument tau. Dia lebih kepada itulah. Argument daripada mazhab-mazhab. Kalau testimoni tu yang diberi kepada saksi boleh memudaratkan saksi tu. So pihak hakim perlu berhati-hatilah, tak perlu maksa ke apa. I think dalam Islam pun tak boleh paksa kan. Kalau testimoni tu tak ada paksaan dalam Islam kan. Itulah dia. So Islam konsep adil tu very wide. You can argue so many things. So konsep adil tu I think you can argue this kind of privilege also lah. But if you ask me about privilege per se, so far I tak nampak lagi. Melainkan kalau mata air rabun. Tapi interesting lah. Kalau you tengok bab 3 tu, Akta Keterangan Mahkamah Syariah, dia ada section 89 sampai 118. Abdul Had So dia ada jenis-jenis soalan yang boleh tanya, ada jenis-jenis soalan ni mahkamah akan memutuskan bila soalan hendak tanya dan bila saksi boleh dipaksa menjawab. Itu dia. So jika ada apa-apa soalan ni section 101 ni Abdul Had mahkamah akan memutuskan bila soalan hendak tanya dan bila saksi boleh dipaksa, can be compelled untuk menjawab So benda ni semua di bawah budi bicara hakim syar'i itulah. Untuk menentukan apa soalan boleh tanya dan apa yang soalan boleh saksi boleh dipaksa untuk menjawab lah. So budi bicara. So privilege against self-incrimination under syariah is mostly under this bab 3 ni, section 101. Budi bicara hakim syar'i. 101. You buka online je, tak perlu cari buku teks apa bazir duit. You buka online. Akta Keterangan Mahkamah Syariah Wilayah Persekutuan 1997. Akta 561. Is it okay Abdul Had?
Okay sir, okay.
Yeah,
jumpa.
wonderful. India pun dah, wali dah, Mahkamah Syariah pun dah. Ada lagi? Anything tak?
Ada sir, saya nak tanya.
Ya Imran, tanyalah.
Untuk Section 132 Evidence Act ni, ada kaitan tak? Ada cross relation tak dengan Section 133 CPC?
133? 133 pasal apa? Lupa. 133 CPC. Section 133? 133 buat what?
Lupa buka mic. Okay. Section 133 CPC.
Actually, what is your about Aku tengah buka ni, 133. PDF file, lambat sikit. Lupa lah, banyak lupa. Okay, 133.
Section 1 bukan bukan 133 ke? 11
Ha? Yang satu ni. Confirm betul-betul? Confirm?
Section 113, admission of statements in evidence.
113 CPC. Sekejap. Aku tengah buka. Okay, 113.
The one yang apa latest amendment 2007 tu, yang katanya dia restore the rule
Except
against
as provided in this
self-incrimination.
section, no statement made by a person to a police officer in the course of police investigation made under this use and evidence. Okay. No statement made to the police. Tak ada kena-mena lah. Tak ada kena-mena lah. Siapa tadi? Imran. Okay. Yang ni pasal admission made to the police. So a confession on admission made to the police, except for certain kind of cases lah, cannot be used later on as an evidence in court of law. Yang privilege tu is person being compelled to answer a question. So that one is more like a privilege in court, testimony in court. This one is a police investigation internally kat Bukit Aman tu, Imran. Maknanya kat Bukit Aman tu you kena investigate kat polis kan. So boleh tak polis pakai apa-apa you buat kat Bukit Aman tu dekat mahkamah? Tak boleh lah. Except for certain case. But majority cannot. Apa case yang boleh?
see. Okay.
In general tak boleh. Tapi apa case yang kita boleh pakai admission made to the police. Ingat tak yang last semester bagi yang brochure tu? Datang kelas tak? Buka balik brochure.
Yang brochure warna merah tu ke?
Merah daripada Majlis Peguam tu, Imran. You buka Bar Council punya website lepas ni, nanti ada buku merah tu. You type je perkataan buku merah, red book. Kat situ nanti dah ada tulis 113 tu. Okey, apa benda yang testimoni boleh bagi dekat polis boleh digunakan sebagai mahkamah untuk bukti mahkamah. Buku merah, red book. Last semester dah bagi dah. Ingat ke bagi Syamir tu? Kat komputer, dekat mana tu? Dekat dia punya WhatsApp tu, suruh bagi korang.
Jadi dia tak ada kaitan lah dengan section 132 tu. Sebab yang dalam CPC tu untuk police investigation.
Tak ada. 1332 tu pasal evidence in front of a judge in court. This 113 is about evidence being used by the police.
Okay.
Imran?
Okay, yeah. Okay. Thank you, sir.
You're most welcome. Ada apa lagi soalan you all? You all? Tak ada? Semua okey ke? Pukul berapa dah ni? 12 suku?
Okey, Doktor.
Semua okey InsyaAllah
Semua okey. InsyaAllah.
Okay, so next week we discuss the next chapter. Chapter ni tak panjang, pendek aja. Examination of winners. And the last week we discuss in August standard and burden of proof. I think okay. Please come for our second virtual special talk this Thursday. Gmail, make sure you have a Gmail email address before using Google Meet. Okay, just go to the link provided by siapa? Syami. Syami semua okey Syami ya?
Okey, Doktor.
Okay, talk ni with Mr. Ravi Niko Okay, lawyer from Hakim Arabi and Associate dekat Bangsa Kuala Lumpur So he's very good guy, very experienced guy Okay, itu dia. Please come, join. Hari Khamis 2 sampai 3 saja. Okay. And ask any question lah. Prima facie tu apa? Okay, prima facie tu apa Okay, how it relate to evidence? Okay, how to prove prima facie case Okay, itu dia. Okay, method evaluation. Okay, don't forget midterm test by today So Syami, jangan lupa collect you punya KLB1 tu. Make sure everybody submitted You submit kat you dulu. You dah okay, baru submit kat I.
Alright.
Okay, take your time, no rush So please semua hantar dekat Syami Make sure you Syami, dalam file folder tu make sure lah you buat apa nombor ke dengan nombor ke atau dengan nama sekali Everybody tolong taruh file taruh nama you boleh tak? Nama penuh dengan nombor matrik tu dekat file tu. So Syami tak payah type nama you dengan nombor matrik you. Okay.
Saya buat saya pecahkan berapa file, Doktor.
Alamak.
I mean like for midterm one file, for case review one file, and then dalam setiap file tu ikut TLB pula.
Okay. Tapi make sure lah semua everything organized Nama semua ada nama student
Alright, sure.
Okay, make sure kita ada 95 student. Make sure 95 orang ada di situ. Okay. Kalau tak hantar, you try to WhatsApp orang, so hantar. Okay. Everybody write down your name hantar. Okay. Jangan lupa tulis nama jangan lupa. Kang hantar macam tu je aku tak tahu nama ni siapa punya. Okay. Ada apa-apa soalan ke isu bangkit pasal midterm ni? Anybody like to ask question? Tak ada kan? Okay. Okay, assignment pun jangan lupa you hantar ya. Assignment. Okay. Hope everybody able to find assignment. Okay. Tutorial assessment, no problem. Take home final exam. Doi. Pening kalau aku take home exam. Final exam ni sebenarnya okey aja, tapi sebab universiti dia nak buat dia punya regulation tu yang susah sikit tu. Okay. Okay, you all. You punya final exam so far 19-20, 2 hari. Okay, dulu 3 hari dah jadi 2 hari dah. 48 jam boleh jawab soalan ya. Oh, bahagia kau, Suhaili ya. Okay. Seronok Suhaili, 48 jam jawab soalan.
Seronok sir.
Seronok Imran, seronok Imran. Okay, so make sure you ada global open access. Seronok
Seronok sangat.
Seronok sangat. Okay. Okay, make sure semua ada dalam, nama you ada dalam Global Open Access Learning System My Goal tak apa, semalam saya dah check. So, Alhamdulillah saya dah check dah. So far, everybody in my class has
Tak pernah lagi. Ni yang barokah.
Apa dia? Apa dia? Tak dengar dia. So far, everybody ada dalam ni So, saya dah tengok you tengok 95 enrolled student Undang-undang keterangan 2 peperiksaan akhir. So saya tengok saya punya sistem goal lah. So maknanya 95 orang ada. So thank you everybody, semua ada. Semua ada 95. Semua ada. Okay. Okay. Take notes So dah check dah. So kalau saya upload soalan ni nanti semua dapat lah. So tak ada kan dapat. So saya tak dapat pun. Okay. Itulah dia. So semua belum upload lagi. Okay. Dalam proses. Baru nak buat front page tu. Okay. Relax. Okay. Okay. Make sure you able to get the question and submit your answer through the goal system because university state. Bukan faculty state. University. Okay. USIM state. You must upload the question through goals. Okay. You must submit your answer through goals. You tak boleh hantar email. You tak boleh hantar WhatsApp dekat tak dibenarkan. Okay, kalau you gagal dapat soalan ataupun hantar soalan dalam goal system, university said you kena receipt paper tu tau. Ambil kau. Okay. So dia ada record student tu. Sama ada you dapat soalan dengan submit soalan ke tak. Okay, itu dia. Okay, you kena submit dalam goal tu juga. So make sure you follow this rule very strictly. Kalau tidak, you dianggap tak berjaya. You kena receipt paper tu lagi tau. So sebelum nak receipt paper tu, you kena hantar laporan ni. Okay, dekat, you kena type, okay, that's why I print kat sini, print screen You kena hantar laporan, apa masalahnya? Tak ada internet, blackout, okay, komputer hilang, kena curi, okay, tsunami, earthquake, okay. So you kena hantar laporan ni sebelum you are permitted to do receipt final exam paper. Okay. So this is very strict macam WhatsApp, macam midterm test tak apa, boleh hantar WhatsApp semua tu. Yang ini sebab diorang nak kena goal. Okay. Kenapa goal sir? Tak tahu. Diorang punya polisi. I ikut je. I argue juga itu. Dia kata kenapa tak boleh pakai my teams ke, hantar WhatsApp je macam saya buat midterm. Dia kata dia kata because they want to make sure that it is a true final exam paper. That's the reason they will use my goal system lah. Okay, so last week we have a meeting lah. So far satu SIM tu cuma 2 faculty je yang ada final exam, faculty law, FSU dengan ekonomi. Okay, ada final exam. Okay. 20. Okay. Law dengan ekonomi je final exam. Okay. So itulah dia Ada apa-apa soalan tak ada? So I think that's all. Okay. So thank you very much everybody Hope to see everybody for our second online talk this coming Thursday. Sila datang sebab ini practitioner ni banyak experience ni, 20 tahun lebih So dia dekat barisan hadapan. Okay, saya barisan belakang. Saya nak pergi depan susah sebab belakang tu banyak kerja dekat universiti. So inilah peluang untuk menjemput frontliner to come in to share dia punya moment experience with us. Okay, we need theory from Muzaffar. We also need some practical idea from practitioner. Okay, to strengthen your understanding on the topic. Kan senang kalau macam ni. So please come 23rd hari Khamis ni petang 2 sampai 3. Itu dia. So Syami, don't worry Syami, borang dia dah hantar. Borang payment semua dia dah hantar pagi tadi.
Right.
Very efficient. Cepat dia hantar.
Okay.
Okay, so Syami tak payah refreshment ya Syami ya. Kan senang Syami. Okay, okay, I think that's all. So thank you very much for our lesson today, and see everybody this coming Thursday. InsyaAllah. Jaga kesihatan diri masing-masing sebab kita ada peningkatan kes jangkitan COVID tu Okay, jangkitan walau tak banyak tapi dah double digit semalam kan. I think PM tu nak buat announcement, so kena berhati-hati semua Jaga diri baik-baik Okay. Tu sebab nak buat kelas pun tak boleh sebab kes dah naik balik isau. So precaution lah. So far kita kena guna online ni lah for the time being So I think that's all Thank you very much everybody Pergilah lunch dah pukul 12 suku ni. Okay, thank you. Bye bye.
Okay, thank you doktor.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam.
Thank you doktor. Assalamualaikum.
Waalaikumsalam.
Doktor.
Thank you doktor.